Really?
There. Sorry, I was talking. I wasn't ignoring
Can I
you.
have a roll call, please? Beth Twig, here.
Can we turn the radio off?
Here.
Yeah, the radio. The
Can we turn the
music.
radio off?
We used to have staff that did that. Yeah.
Mary Langdon.
Here.
Just have to wait till Will returns and turn him off the radio.
Thank you.
Bill Crouch,
Here.
Max Crawford here. The meeting been duly noticed?
Yes.
Can I have a motion to approve the agenda? Can you hear this?
No.
Can you hear it now?
Much better.
Yeah, if you speak into the mic closer, it's better.
Can I have a motion to approve the agenda?
I make a motion to approve the agenda.
I second. Okay, those in favor? Aye. Aye.
Aye.
Aye.
Aye. Agenda's approved 5-0. Old business, discussion and motion to approve the guest exception policy. Okay. In November, those might have remembered
How are you?
that we voted to implement a policy. Just exactly what that policy was the little gray. Does everybody have a copy of the policy? I can read the policy out bit by bit, but basically what is going to happen with the policy is that we are going to allow usage of the facilities for people who are not taken care of in the covenants. We're going to limit it to 6. There was some concern amongst the board that this was just an open-ended policy, and if 6 is too many, we can revisit that. 6 was a sort of arbitrary number. Renters would have to have a transfer of usage, which preserves the rights of the owners who choose not to transfer usage to the renters.
Excuse me, Ellen.
Yeah.
Can we discuss it for long or you want to wait?
Okay. Shall I read it paragraph by paragraph? Maybe that would be a better way.
All right, so I'm asking you to discuss it after
last
the
week's,
paragraph.
that's
or
different.
When you get done reading the whole thing.
This is back and forth. That's not.
Why don't you interrupt when you've got a question?
Okay, I got a question.
Okay. Well.
Can I look at this?
Okay.
I have.
I was trying to understand the part of the no more, this is the second paragraph.
Okay.
No more than 6 residents per household may use the common areas, recreational facilities under the residential. Okay, so suppose I'm family of 6. Okay.
Okay.
Mom, dad, okay, it's a conventional. And in addition to that, I can have 6 others live with me? I'm kind of confused. I was looking for a overall cap, and this seems to be a cap exception.
It's a cap on exception. Now, we can, if 6 is too many.
Yeah.
Well, it says the board has the right to change its policy at any time.
Yeah, and that's what we're here tonight, to decide whether 6 is too many, whether it should be 4, whatever it should be. So this policy is intended for people who are not already covered under the covenant. So in your example, they probably are all covered under the covenants. If they were renters, obviously some of them wouldn't be. You know, if they were in a 4-bedroom house.
Well, I'm just saying, and you know, if I'm a family of 6, normally, you know, say conventional family, or lacking of, anything else to say. If I'm a conventional family of 6 people, I can add 6 more people to my household, and they would be allowed to come.
If they can prove they're living in your household, I mean, if you live in that overcrowded state, yeah, I guess.
But I was looking for an overall limit. I know you said you could change it, but
Yeah.
you know what happens when you start changing things, then, you know, we'll be in the same predicament that we already were in.
Right.
You know, because you're gonna have to rescind somebody and,
But what's a common practice now that people have been signing up for some of this? How many people are actually, I don't really think that 6 people would probably be signing up anyways in
Right.
a typical household.
Right, and I mean, you can always give an example that's extreme. For the renters, I would say the most common is when you've got one child over the number, because for the renters, certainly, they never count that the parents share a bedroom.
Right.
So, and I mean, if you've
So
got,
it's a
if you've got
4-bedroom
small,
house, there's
yeah.
only 4 people and you probably need 5, so you're only really adding 1.
For the renters, yeah, it's usually the family that's over the number of bedrooms, because, I mean, if you've got 2 children and you've got 3 bedrooms, you know, 1 child in each bedroom and 1 bedroom for the parents, I mean, that's a bit archaic.
So
like every person-
let's drop this down to 4 then.
I think I'd be more inclined to drop it down to 4.
yeah, I would too, but 6 is just, to me, too abusive.
That
Because,
just seems
see,
like-
and although it may not have been in the past, because it wasn't allowed, I don't think, to this extent, but as word gets around, you know,
Right, yeah.
next thing you know, it can cause a problem, so.
I'm okay with that, so we're gonna make that change.
Yeah, let's.
Mary, do you have anything to add to that? Jan is pointing to the second paragraph, the second sentence. No more than 6 residents per household may be approved to use the common areas and recreational facilities under this resident usage policy. So we're gonna change that to 4.
And we're gonna still leave the caregiver on there.
Well, the caregiver probably wouldn't be, caregiver is a special case. The
Correct.
caregiver is not usually a resident. Now this came in because we actually had, okay, yeah, we're just gonna pause while Bill makes more copies.
Second
It's in the
paragraph.
second paragraph, second sentence. Second paragraph, second sentence. Okay, the whole thing about the caregiver, was, and again, the caregiver is a special case, you know, that's gonna be under the board's approval. I mean, that's obviously a real caregiver. But this came about because we had, a disabled veteran who wanted to swim, but couldn't get to the pool himself, so his caregiver who lived with him. But I mean, it's gotta be a bona fide thing, you know, you can't just say, well, you know, here, I live outside Hollywood, see, I'm the caregiver. The caregiver can only come in with the person who they're the caregiver for. So, you know, that's great, they don't get carte blanche to come in.
This is what the word that I can follow. I wanna keep that.
Okay, the one you're supposed to have has like a list of names on the bottom.
That's the last week.
They didn't print
Just
the backside.
name.
They didn't print the
Oh,
backside.
the backside's not printed.
Oh.
Well, it's a separate sheet. Oh, you mean when they copied it for you?
I only have one.
Here.
Yeah, the backside is a release of liability.
That didn't change, right?
No, that didn't change.
So, did you see the South letter?
Yeah, I saw the stuff.
They answered for the insurance, we paid that.
Yeah,
You
you,
wanted that multi-red. Is that on there? You wanted the whole letter.
so let me just go on through it until you've got another place, okay? Okay, I'm gonna go on. This is renewable, and And this is so that, when you get it, we have to check every year that it's got the same number of people, you might have a child that's gone off to college and left home. We don't wanna keep the same people on. The Florida driver's license, the government issued ID card, the voter registration card. So these are things that would prove that you lived in the household. Obviously, I say not obviously, but the owner would have to be current of assessments, good standing on all amounts, covenant violations, fees, fines, assessments. And, okay, Dan Ramsey pointed out on number 4, and I corrected number 4. It should be one more sentence. This only applies to renters. And the sentence now reads, the occupant residing in a Holly Bunny
put it right there.
home
Yeah.
has to have a current transfer of usage form on file with the association. This only applies to renters.
Thank you.
Good.
Yeah.
Which is a good point. And again, this is for people who are not covered under the covenants. So, 5, you've probably got some children covered under the covenants. This is just for your extra one.
Let's retry it, because I think that's another one.
A parent of any child under age 18 must complete this form on behalf of their child, and by doing so hereby affirms the child is a resident of the household. Any individual 18 years of age or older, yeah, I guess that's a misprint. I'm gonna edit as I go. Must provide proof of address in the form set forth in 1 above and execute this usage policy.
If I may make a comment on number 5, that's our current policy now,
Yeah.
so I don't even think we need that statement in there.
I'm not sure we need it, but there's something about it that strikes me strange, so it sounds like what Bill is saying to me, but I'm not sure.
What?
A parent, number 5, a parent of any child under age 18 must complete this form.
On behalf of their child, and children don't get to complete the form.
Well, yeah, I know that, but what I mean is, it sounds like it applies to every family, not just renters, or not just for every.
No, I mean, it says,
Well, but
front, this is for the exception.
This
So-
could be like if you have, if
2
I'm,
children in a 3-bedroom.
yeah, if I'm the one that has the access to it, and you're living with me and you don't have access, and you have children, I'm gonna put you and the 2 kids on there. See what I'm saying? Right.
What do you think? I'm just,
I see what you're saying. I don't,
So if I have this big old 4-bedroom house, and well, it's not just for renters, I mean, it's gonna be, if you've got a family that I'm engaged to somebody, and he or she doesn't have use of the facility, and he or she has a child that is not on my side, that doesn't belong to me, I'm not
I
gonna
see.
deny that child.
is that already covered in paragraph 2? You can have 4 people. That's not.
Yeah, but if it's not my child, that would be an exception. Correct?
Okay,
See,
but I don't, to me, that doesn't say that, okay? I see your point.
I don't think it hurts to have that in there, though, does it?
Well, I don't know.
I mean, in the past, when these have been crafted, there's been a list of people, and that's kind of been a problem, and there was certainly an issue with foster children, stepchildren, whatever. So we take out all the definitions, and we just call them children or adults, or whatever, We try and be as non-specific as possible. Because that's where, every time we've had a list, there's always been somebody. And I know that, just before the election last year, there were issues trying to craft something, and there were about 20 different definitions of who it could be, and of course one was left out. I forget who it was, but you know, that's what makes the thing not acceptable. And then 7 is the caregiver, you know, the caregiver. And I think this is very, very few, but you know, if you're going to do it, you might as well try and get everybody in.
I do have a question. Let's take an example. Let's say that that there's mom and dad or parents with 2 children, and then they have 2 other people living with them that aren't in their immediate family. And the other 2 people are allowed to use the facility, and then let's say that one, they have an argument and one goes to live across the street or maybe right down the road, and it's not reported. How do we have any control over that?
You don't, except for at the end of the year.
Yeah, that's right.
Okay.
And if they don't apply for a change of address, they don't. Part of the identification we're using is a driver's license, for example. And
Yeah.
I forget what else.
Government ID,
ID,
voter
voter
registration.
So if they leave and they have to reapply for this next year, if they didn't change their address yet on their license or whatever they use here to confirm that they have that.
Well, but don't forget the owner has to apply. So in other words, if
Well,
you
know,
well,
we'll do
right,
things for friends and relatives.
right, but I mean, in his example, some people left the home and they were no longer in good standing with the owner, so next year he wouldn't apply for them. I mean, there's almost no 100% foolproof way of doing this. I mean, we're trying to sort of bring it into the 21st century a little bit. I mean, you've got some instances that are really where we're on the wrong side of the law. You know, where you've got same-sex couples, and you've got partnerships, and I think you really need to do this. I mean, if you're both on the deed and you've been together for 30 years, to me it just seems incredibly harsh that you should not be allowed into the facility.
Yeah, and I just spoke with a lady yesterday that she came in. Her son is the one that's actually on the deed, but she lives with him because she has to take care of him because he's disabled. But they put him on the deed, but the parents live with him.
Well, in that case, they'd be a caregiver.
Well, not necessarily. It's his,
No.
they live with him. It's his parents.
I mean,
not a full. They're not. They just help take care of him. But they live with him, and they can't use the facilities because it's just in his name.
So you might have an elderly person who owns the house, and because they're getting on in years, maybe a divorced child who could very well be retired and in their 60s comes to live with them. Right now, that person would sort of be acting really as both a caregiver and somebody who's living in the house. You know, 2 sisters living in the house together. I mean, only one could come in. There's a lot of hardships. And I think the chance of it being abused is less than kind of how we're sort of abusing some of these families. You know, who are we to say what constitutes a family? Yeah, okay, I apologize, we were having a discussion, but I tell you what, if we get a motion, then we can open it for discussion. So can we have a motion?
I make a motion that we approve the resident use policy with amendments of no more than 4, and on line 4, the word renters is placed in there to indicate a transfer of usage.
A second. Okay, motioned and seconded to approve the guest exception policy with the amendment of the number of exceptions granted per household and the caveat about renters. The discussion, go ahead.
Beth Welter, 1948 Resort Street. Where are you guys getting the authority to make a policy on who can use the facilities?
We're getting the authority from,
Turn your microphone on down.
I want to know where you're getting the authority to change who can use the facility.
from the legal authority that Michelle Ankus gave us, and also by the cruise. I didn't think I was going to have to show that piece today, but okay, I'll find it. Yeah, I'll find
Because
it.
the reason I asked it, if you're using section 4 in the bylaws, subsection A, that only applies to making rules and regulations for the uses of the common area, not who can use it. The only place it talks about who can use the facility is up in the covenants under section 4, under restrictions of easement of enjoyment. That's why I said last week, the best way to fix this is to state the federal and state laws and use that instead of trying to make a policy that can be changed by the next board and every board after that.
Yeah, but that doesn't encompass all of the people that really need to be included in this.
Yes, it would. It would encompass family. The definition of family has changed since 1970.
Right, but there are still people living in the household, caregivers and things that, you know, what is the definition of a family?
There's also dependents that are considered part of the family.
Right.
So until you research that,
This-
I don't think you have the authority to change who can use a facility.
That's not what Michelle Anker said, it's not what the cruiser said.
Unfortunately, when Michelle Anchors was the attorney while I was on the board, she said just the opposite. She said that we do not have the authority to change who can use a facility. So obviously, the attorney was only going to do what you wanted.
No, I don't, the reason that she had a problem with the policy before was that it was too restrictive and had the feel of discrimination. That's why,
She didn't even have the policy when she gave us the reading that we don't have the authority as a board to change who can use a facility.
well, I can just go by what these lawyers have said now to us.
I think you're going about it the wrong way, and you need to go with federal and state laws, because the next board could change this policy again, and then we gotta start all over again.
How would federal and state laws apply to this?
Because our covenants, if they're outdated and they're in violation of any federal or state law, which they are because the definition of family changed since 1970. The definition of family now includes same-sex couples, stepchildren, foster children, exchange students, dependent children that are over the age of 25. So that would cover almost everybody that you're trying to let in here right now.
Well, it
So
wouldn't, cover people who, like I said, have got an
You
older,
care better. You care them.
well, I wasn't specifically saying the caregiver, but my example, where you have an older person who has a relative moving in, or who has a sibling.
That's considered a
moving in.
family in some of the state and federal laws.
Well,
You need to research that some more, because right now you're making a policy that in July could change again.
and it could indeed change in July, yes.
Which would open up a big problem, I'd say. I think you've got a good point.
I bet the only way to change our covenants is to be sued and have a judge change them. Or we change our covenants by a 50% plus one or whatever it is, then we need to change our covenants. And that has proved to be a very difficult thing to do and almost impossible to do in the past. So, other than being sued and being on the wrong end of the suit and forcing the covenants to be changed in that fashion, I think this is the next best thing.
So if it's too difficult to do it the right way, we just do it the way we want.
Now, if we do it this way, and people have a problem with it, and what is said that we have covered the cases of the family, then it would seem we would win if somebody wanted to sue this.
In fact, going back to what Bill just said, excuse me, way back when Ryan was still here, probably back in October, and having read one of Michelle Anker's letters concerning this, Ryan and I had said the same thing that Bill just did. It sounded like in the letter, basically, let somebody sue us. In fact, it seems to me, now that I think of it, when we were sitting in front of Crew and Crew doing the interview, that came up, and I think he agreed with that. Didn't remember that, it just came out.
Well, if this policy is such that people are gonna sue us, I think they're gonna sue us either way. This is an attempt to cover the missing piece in our policy. I think these people have waited such a long time. They used to be able to get an exception. They used to be able to, they've moved into this community, they used to be able to use the facilities.
Well, isn't this far more reaching than what you're talking about, how it had been?
No, not really. It's, it was arbitrary before. And if one day, Jan is making the decision and she decides, A can come in, and then Beth tomorrow decides, no, someone with a similar situation can't come in, it's arbitrary. There was nothing written down. It was voted on. So it was like the fences, one day it'll be this and one day it'll be something else. There's no consistency. This is more open, so you're not really discriminating against anybody. I guess if you're the fifth member, maybe we are, but I mean generally you are not discriminating. You're not saying, these are the ones that can come in. This was really the main issue, and we went over this when Ryan was here, and we crafted a policy that was very similar to this, except it had no limit. And I know that the board wanted a limit. And we went back, and I think that the two changes on this was, how it would be stated. Last time we had, I think, non-resident owner, but that was an ambiguous term because you could be a resident owner. So really, it was sort of designated. If you've got multiple owners, only one is designated. And then the other was the restriction, so we've got a restriction to 4, which is more than reasonable. And, obviously you have the capability, because it's a policy, to rescind it, to change it, to do something. But I think we should at least be trying this.
I'm Dawn Griffith, 6648 Castlewood Street, and what you've just said was exactly what Beth was trying to say, that you went to all this trouble, and I know your heart was in the right place, but you went to all this trouble that this policy could be redone in July. You've spent a lot of money with an attorney on this. I don't know how much, but we're running out of money. You have used a lot of money for different things, to forms and this. I mean, I have a separate form today than I did last week. And her point is, if you do it by state and federal laws, you don't have to worry about the policy changing. You don't have to spend more money. The new people that come in July, they can hire an attorney. He doesn't care. He doesn't care how many times he's going to rewrite it. He's going to laugh all the way to the bank. That's what attorneys do. And so for you to keep using the attorney and use the attorney for July to come, and we have a new policy with new people in place, is foolish. We should do what Beth said. I mean, I know you have your heart in the right place, and I think it's a good idea, but I think it's frivolous spending of money
to just go ahead and put a policy up that the next time it can be changed, and the next time it can be changed. This needs to be done, but it needs to be done with a finalized, this is the way it's gonna be, and the board can't change it, because we've done it properly like Beth just stated. And I wanna say that on record. Thank you.
The only issue that I have is that whatever policy you come up with, if it is contrary to what is in the governing documents, it's useless. If state law overrides the governing documents, then state law is what's there and what is to be enforced. You know, usage rights as far as what a family is, if our policies are discriminatory in our governing documents, they're void automatically. State law trumps, and if we don't enforce according to the state law, then we are in violation, can be sued at that point. Now, as far as, you know, if you come up with a policy, you know, unless it specifically states in the documents that you can come up with a policy to augment it in lieu of what's in the documents, it has no standing. So, you know, the rules and regulations are inferior to the governing documents, that are inferior to state law, that are inferior to the Florida Supreme Court and the federal Supreme Court. So, whatever you do, you know, if you do something that is contrary to these documents, if it goes to court, these documents are going to supersede whatever you come up with. And, you know, the family thing is taken care of on a federal level. And the only thing that's in here, in the governing documents, talks about children under the age of 25. So regardless of what the federal government says, our governing documents say children under the age of 25. If you are over 25, you don't meet the requirements under the covenants. If you're a caregiver, you don't meet the requirements under the covenants. That's what the exceptions are for under variances, and if the variances are only for hardships, and if it's a hardship. So, thank you.
Well, quite honestly, every week I get an email from a resident what? And it is a hardship to them. It's a hardship when the partner can't use it. It's a hardship when.
And so they come to the board with a variance request, and you either grant it or deny it.
Okay, but
That's how it works.
the point of it is, all of the variances were rescinded.
The variances
So we
are
are trying
individual
to.
case.
No.
No, variances
Right
are
now
for
we have-
individual hardship cases.
It's
No,
architectural.
please.
Oh, no, architect?
No.
Yeah, that's right.
Okay.
Architecture.
Okay, order please. Let me just say, in December the 31st, 2013, all of the usage was cancelled, so that people that had been coming in could no longer come in. So we have for a year and a quarter been trying to craft something to enable the people that used to use the facility to be able to use it again. Now, there are some people who don't want anybody to use the facility except the ones exactly specified in the covenants. I understood the usage policy, usage policy that we used to have was arbitrarily applied. There were no set rules. You know, like the fences, just exactly like the fences. It just depended on who was looking at it and what day. And this policy is non-discriminatory enough to stand. If another board wants to rescind it, I believe it's a lot fairer than the policy that they had before, whereas, you know, two people with the same condition, one maybe got the variance and one didn't. The fact that we've said, you know, you're a resident of the home, and that covered.
That's the point about federal and state law in regards to discrimination. would also cover it.
Right.
So,
And would have a strong leg to stand on.
But again, we would have to go in and change the covenants.
no, you wouldn't.
What is our
I'm
policy?
thinking that what's being said here is we do not have to change our covenants if we are obeying state and federal laws.
But except that this can be changed.
I understand.
It could be changed at the whim of any next board.
So,
But
is
so
it true?
can any
excuse me,
policy.
Is it true that we can grant a usage if the usage is, if the people that are requesting the usage are the, fall under the state or federal laws that should allow them to use it? Can we just arbitrarily say, okay, you can use it because we're in violation of state or federal law?
Yes.
Yeah.
What I'm saying is make
We
it,
can do that?
I don't know, I'm not a lawyer, but it seems to me that
If
if
we.
you got a copy of the law she's talking about,
what I was suggesting at the last meeting is the board has the ability to make a policy saying that our covenants are so outdated that this particular paragraph is against federal and state law. To be in compliance with federal and state law, this is our policy for ease of enjoyment for the common areas. You could just do a policy like that. Also, just so you know, in our covenants, it also says failure by the association or any owner or subdivider to enforce any covenant or restriction herein contained shall in no event be deemed a waiver of the right to do so thereafter. So just because the board did something in the past, that doesn't make it right now.
That's right, I fully acknowledge another board may come in and rescind the policy. But this has gone on for 15 months. And I think it's most unfair to the people who fall in the middle of this policy. If the next board wishes to rescind it, that would be up to the next board. I would ask on behalf of the people who should be allowed to use the facilities, who are not, that tonight we pass this policy.
I have one question for Beth. Just because if we decide to go that route, but that does not, if there's two people on a deed, and they're not married, that defeats the purpose, correct? Because say me and Jan are on a mortgage together, does that mean that she can't use it? Because we're not family.
It considers you family. You do not have to be blood relatives, you do not have to be married. It even gave an example like that. Two people sharing a home, they are considered a family. It was in some of the definitions under family law. It even covered some caregivers. It said that in the cases of a caregiver living in the home, that person can be considered family.
Well, then in that case, if what you're saying is that this meets the criteria of family, by passing it's the same thing. If you're saying that, no, but she's saying that people living in the home are family.
Well, she's saying that we don't even need this.
yeah.
She's saying we
That's
don't.
what she's saying.
She's saying we don't need this because all we have to do is go in and,
You could just say our policy is to follow state federal laws.
That's it. Yeah, but how you gonna track it? How you gonna know who's coming in and who's going out? You have to have some type of documentation, whether you use that form or not. I agree with Beth, but you gotta be able to have some kind of control.
See, and this is why the year, now, let's make sure he's not here tonight, but my neighbor, has a friend staying with him, and this month it might be this friend, and next month, it might be another friend. Are these all his family? The fact that you've got some limit on it, I absolutely agree. You just don't grant this, because they could come in and say, well, all these people are my family. This provides a limiting factor. You have to fill out the form, you have to say that they are belonging to your family. You know, as opposed to you've got the, you know, 6 girlfriends a year or whatever that come and stay. And they go out of the neighborhood and they still got this because you just granted it to everybody.
Well, you still have to be able to prove residence,
Right.
don't you?
Yes, you do.
Okay, so if somebody's gonna have 6
Every 25.
proof residence in Holly by the
Right.
Sea, not in the state of Florida.
Right, but this does actually give something. We've got a record of the people that are allowed in. We don't just say, okay, Jan, you come in and you've got a whole bunch of people living in your house and they've got driver's license or whatever. So we just let them in on your say-so. We've got no record of it. This way we do have a record of it. We have a record of who the people are, and they have to reapply every year. And it does have a kind of limiting factor. I mean, I agree with what you said. Whereas if we just say, well, anybody in the house, we have no knowledge of who is in that family. I think the fact we've got this forces people to come and apply. It's a paper. They have to show their proof of ID.
Well, they had to anyway to get a tag. Yep. I mean, I remember when we moved in, we rented before we bought it here, and we had to apply. We had to come here, we had to show our ID, we had to have, you issue the tag. So that's record, right there.
Right,
Okay.
that's a record.
Doesn't
but
matter how old they are, they can be 5 years old, they still have to have the tag.
They still have to
Okay.
have a tag, but then they could keep the tag, you know, after this policy ceases to apply to them.
It has to be updated.
But again, here you've got the record, so that you can update it, so you can see, okay, you've had it for 12 months, now it's time that you reapply, or these people no longer have the usage rights.
Wouldn't that be in the computer? I mean, it's in there. Not a piece of paper, that's outdated, it's in the computer, everything's in the.
Okay, but the fact you can track based on a date, so anybody who's got this past a certain date, you can go in and make a list and say, well, these are now, you know, these are now invalid. It's a way to control it. It's a way to control it rather than just saying, well, we're gonna let anybody in who thinks they constitute a family.
I can see that, that this form and the state and federal laws, if we eliminate number 4 and number 5 from this form, it basically allows us to be compliant with state and federal laws.
No, I think you have to have number 4 because
No,
you have
no, you
to,
don't.
you do, you have
No,
to
because
preserve.
they're renters and they're not considered a family owning a house. They are living in, that's the policy for them. And I can't see how we can make an exception on renters when they've already got the exception.
How have they got the exception?
If
But they
there's
only-
5 people living in that house and they are considered renters, they all qualify. There's no rules and regulations to really cover them.
Only if
No.
only if the owner does the transfer of usage. That's why I think she
But
needs.
that's why it's in here.
That's where the number of bedrooms comes into play.
Yeah.
For renter. The number of bedrooms comes into play for renters.
We already have that policy?
No, it's
No,
in
it's in the
covenants.
covenants.
It's in the
They
covenants.
rated it wrong.
Oh, yeah, that's right, yes, yes.
Just so you know, the only reason I'm talking federal and state laws is because by using that, you're not violating the covenants. By making that policy the way you're doing it now, there's nothing in the covenants that say you can do that. That's my point. There's nothing preventing you from utilizing what you have in some kind of a policy that at the top basically says, due to federal and state laws, our covenants are outdated, this is our new process, and then incorporate some of that stuff.
Well, we could certainly add that, Can I just go back and reply to Bill's question about the transfer of usage? You absolutely, okay, that's already answered, okay, because we don't want to override anybody's rights. So we can certainly put that as the first sentence, due to
Where are you putting that on?
We can always say as it applies to state and federal laws.
Yeah, but she's saying that we have to go, but she says not to change it on this form.
Well, why can't we put as a caveat to start with, due to changes in state and federal laws, state and federal law, the covenants have become outdated. And to comply with the new definition of a family.
It's not new.
Well, it's new since the covenants. News are relative.
Current.
All right, wait a minute.
And you can also write it so that it changes with the state laws. As the state laws and federal laws change, it changes with it.
Okay, let me go back. Due to changes in state and federal law, the covenants have become outdated. And to comply with the
Current and future federal and government.
Why can't
well,
we?
just we don't know what the future is, so if we just say current, it's always current at that time. Yeah? To comply with the current laws, or the current definition of a family, the board will implement the following policy.
Can I interrupt for just a second?
Sure.
Instead of more words, why don't we go with less words and say, the board recognizes the current federal and state definition of family, period. That's all we need to go.
Okay, wait a minute.
We need
Stay
to-
up there.
We recognize the federal and state definition of family.
Go back, sorry. Go on.
This board of directors,
Well, wait,
No.
that's it, change it. Just say.
Just say it once, but
Okay.
slowly.
the board of directors recognizes the current definition, the current federal and state definition of family, period.
This board
With
of
regard
directors
with regard to
recognize-
usage, the board recognizes the current federal and state definition of family.
Why would you say board? Why wouldn't you say the association?
Okay, you're right, thank you, Dan. The
Okay.
association recognizes the current federal and state definition of family with regard to usage policy. Sorry.
I'd just like to
Okay,
make a
I'm
comment
gonna-
also.
Can I just make sure I got this
Okay.
before you go on? This association recognizes the current state and federal definition of family with regard to usage policy.
Period.
Yeah.
Oh,
Yeah,
That's what I got.
I still think that we need to have some type of tracking method. So like, let's say, you've got a 19-year-old boy that lives on Edgewood, and his best friend and him like to work out together. And he lives on the other side of town, doesn't live in Honolulu City. What's to stop him from coming in here? We still need, for the exceptions, even though we're gonna follow the federal and state guidelines as far as letting people in here, we still need to track it. We need to have some type of control. And, whether it be a form modification to what you had there, but we just can't just say,
I agree.
Isn't that what guest passes are for?
no, because because they're not guest passes, because these are family exceptions, we'll call them.
So
Right.
what would happen? What would happen? My family, I'd go in there, I would fill out the form, we would put it into the computer, we put the date, so that when the date turns around to the year,
They reapply.
yeah, they
Just like-
reapply, or they'd be cancelled like they are now for certain things. But we would have, somebody would have to show and vouch that this child belonged to the family, not lived, you know, in.
Just because she's a workout
or-
buddy or
Yeah,
whatever.
yeah, exactly. So we're gonna couple the two things together. So we've got the form for tracking and for verification, and we've got this sentence that we're gonna put in the front.
Yeah, because not every household needs an exception.
Exactly.
But there are some out there that
Exactly.
do, and those are the ones that we need to
Yeah.
keep some type of control on.
Exactly, and I think, you know, I think we tend to go to the extreme and say, oh, you know, and I've heard this before from many people, a church is gonna come in and buy a lot, and they're gonna say, you know, 2,000 people are their family. It's like, you can always, no, I've heard that one. You can always go to the extreme. But, you know, while we've got people who really need this, I think if we put this at the beginning of it, we keep the form, I think we've got, you know, we've got something good. Because not everybody wants it. I mean, really, the ones who do feel very passionately about it, and it is a hardship. I mean, it's heartbreaking to read some of these stories where maybe the father gives up his pass so the two kids can have a pass each.
Yeah, somebody just
I
needs
mean,
to validate whether or not, you know, the application for the exception is not being falsified.
Right.
The
That's
federal
all.
and state guidelines don't recognize bigamy. I mean, it's, you cannot have more than one spouse, no matter what your relation. You have one spouse, that's it. But your neighbor can only have one spouse at a time, whatever his spouse
Girlfriend
is.
this time, yeah.
Well, let me ask a question.
I know what you mean.
But he can only have one at a time.
Yeah.
So when one leaves and he goes to sign another one,
Then
he's gotta
you
take the
say,
other
well,
one
you
off.
had one already, who is it now? Yeah,
Yeah,
exactly.
take the other one off.
Yeah,
I don't care how
yeah,
many
because you've got a
times.
record of it.
I don't care.
Is it a year from when I apply or the calendar year?
Anniversary.
Anniversary date
Is
of
it
applying,
anniversary? I don't,
when you apply,
And who's gonna keep track of all this?
it'll be in the computer.
does it say that in here?
Well, I mean, that's how we keep track of children getting to be, you know, 25, whatever it is now.
Well, I'm just saying, within this, does it say, a year from your application, or does it?
Yeah, it's in there.
Yeah.
Okay.
Not to confound the issue anymore that already has been muddled, but going back to the authorities issue of what would give the board the authorities for this, we can fall back on state and federal law for certain portions of this, but one area that would not be covered under that is when you start looking at the caregiver portion of it. That might need some redress in
Yeah.
how we're looking at it.
Caregiver is covered also.
But would they be considered a family member if
Yes.
not living in the
There's,
household?
I was looking into some family law and it said that a caregiver that lives with the person is considered family.
But what about
Well,
somebody
no,
who's
this would be a
who's not
caregiver
living?
who doesn't live in that.
We probably have to talk about that.
But again, that's a special case that we're saying, you know, how many caregivers are there? I mean, that's a very special case.
Charlie was talking about who's gonna keep track of all this. Just so everybody knows, when anybody checks in or a new member, they identify who all their family members are, so we already have a record of it. It's not like they're just gonna be bringing in anybody and everybody,
Right.
they've already got it. List them.
Right. Okay. Ready for the question board? Okay, the motion is to approve a guest exception policy as amended. And it was amended, I'm just gonna say that with Andrew's sentence. The association recognizes the current state and federal definition of family with regard to usage policy, and we're gonna put that right on the first part of this. And the change of 4 in the, which would now be the third paragraph, and the sentence about the renters, so that we preserve the rights of the owner not to transfer the usage.
And correct the word old to older.
I'm in favor.
And correct the word old
Yeah,
to older.
that's right.
Oh, yeah.
Okay. Those in favor, say aye.
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 Okay, you don't feel the need to abstain this time, as you had in the past?
I had, I asked about this, I haven't, abstained in the past, I voted.
Oh.
I abstained for the discussion, but I had discussed it with the crews that this was really not applying, that I didn't have to abstain. But because I have, in the interest of full disclosure, I have a 30-year-old daughter with Down syndrome who lost her usage rights in December the 31st, 2013. But even if I hadn't had a daughter like that, I still think it was the right thing to do.
No, she disclosed.
Yeah, I
That's fine with me.
disclosed. So did Jen vote?
Yes,
You
that's my
voted?
answer. My answer is yes.
Your
Yes.
vote was aye?
Yes, my vote is
Oh,
aye.
okay. So the motion carries 5-0 to pass the guest exception policy as amended. Do we need to read that out again? And we go with it, okay.
Okay, I'll get your notes.
Moving on, yeah, I think you better get my notes and we just read. Okay, so now we come to what we tabled before, the canvassing and signposting. We have passed, in the current policy, does everybody have a copy of this called Holly Valley Sea Improvement Association Rules and Regulations regarding campaigning, canvassing and signposting in common areas and recreational center? If not, can you come get one now?
Thank you.
So we,
Excuse me, what's the difference between discussion and motion and discussion and decision?
thank you. Decision, motion. It just depends, I guess, what it was complicated, right, okay. Okay, so, what I thought we would do is go through this and add to the one we've got, which is canvassing, campaigning and signposting in the lobby areas and walkways is prohibited. But we're gonna need to make some, I don't think that's mine.
It is yours.
It is mine? Oh, okay.
Every time you pick it up.
Okay.
What are you comparing it to? I'm missing something here.
What do you? We have nothing to compare it to. We're gonna
No,
discuss it.
no,
tonight
we're
so
gonna
we can
discuss
watch
it, and we're gonna add it to this little one-line policy we voted on the other night.
I don't remember voting on it.
Yeah, we voted on it. Canvassing, campaigning, and signposting in the lobby area and walkways is prohibited. We did this, who remembers when this
April
was?
8th, I believe.
Was that a special meeting? No.
No, regular meeting.
Was it a regular meeting? Okay, so we have this one piece.
No, it would have been last week.
No, it was a special. It was special. It
was a special
It was a
I think it was
special.
the April 8th.
I think it was a special meeting, yeah, it was a special meeting. We had so many special meetings, so many meetings,
Did we publish the approval minutes yet?
Yes.
yes. And we actually had it posted, we had this posted,
Just that part.
just the page that we passed. We passed that one thing, right. So now we're gonna see if there's anything more in here that we can pass, okay?
Which one did you pass?
I'm gonna read it again. This is what we passed. Canvassing, campaigning and signposting in the lobby area and walkways is prohibited. In other words, we're gonna keep the lobby area free of everything. But now we have people running for the board, so we need to see if there are any other issues here. Now, let's go through them. Number one, and we can edit and make comments.
Well, number one isn't number one anymore, right? We got
Oh,
another
well,
one.
okay, number one on the sheet, which would be number two. We're gonna add it to what we've got already, but we're gonna go through this sheet that has 8 things on it. Okay, you got that?
Yeah,
The old one, okay. So, posting of notices, advertisements and signs in any common area or facilities is disallowed for any matter that does not directly involve the business or operation of the association. Comments, Paul?
Well, you have allowed, I guess you meant to say disallowed, you have allowed.
Oh, disallowed, did I say allowed? I'm sorry, I meant.
No, you did say disallowed, but the document says allowed.
I have a
The
question.
document says disallowed.
Mine says disallowed.
Mine says disallowed.
Mine says allowed.
Mine says
Disallowed, it says disallowed.
Oh, I thought we were moving the two.
No.
Oh.
We're
Following
gonna
number
do
one, two,
number
remember,
one, which
one
would
becomes
become.
two.
I just wonder, what's the problem? Like, why did you find it necessary to come up with all these restrictions in the facilities or in common areas? I'm just not sure, because, I mean, I've lived here now for about going on 12 years, and I've been through a lot of elections, and I've never seen any problems that would cause any board to put these type of, these type of restrictions, I call them, that are skating right on top of 720 to the membership. So maybe you can explain to everybody why.
Basically, this is to preserve the rights of everybody. And actually, this was drafted by the attorney, but if you want to get to the sort of nitty-gritty of it, I would say that what we don't want is things that some find offensive or disturbing. This is a recreation center. As long as what is up there is not controversial. I mean, we've had one member puts up something and another member objects to it, and they almost.
What has been, no, but you still didn't explain it. What has been controversial and what has been, I'm looking for specifics, let's just say. Could you provide us with specific examples of what you found inappropriate and in the past and going in the future? I'm just not understanding specifics. I'm not, please don't be general, because it's not working. And, as far as the attorney goes, he might have written this, but I think if push came to shove, I don't think that this would stand up in a court of law, because at the end of the day, we're all bound to 720. And if he's telling you any different, then maybe you ought to think about searching for another attorney, because he doesn't sound like he's following the law. But I'm sorry, but just let's hear some specific incidents or examples of inappropriate things that would cause you or this board to come up with, a list of restrictions for the membership.
Okay, this is a recreation center, and people come here for recreation, for peace and quiet. If there is anything, and I have to be broad, if a member decides they're going to post comments about another member, about something.
Has that happened?
Yes.
Where?
I'll explain.
No, when you come up here and explain.
Yeah, let him
it.
come up and explain. I don't really wanna get into a he said, she said, whatever.
Well, no, because I'm asking for
But-
specifics.
But this is what
I'll
I'm
give it to
trying
you.
to not be specific, because I don't wanna, there are specifics. Let Earl come up with
When you
it.
limit our freedom of speech, you must be specific, you must.
I got a couple of things that I can mention that probably will fit this bill.
Oh, could you talk down the microphone?
Can't hear you.
Most people can remember last year. If you can, I'll bring it up to speed.
Could you get to the microphone just somehow?
Billy Neal,
That's it.
a good friend of mine, was canvassing in the lobby, and I had no objection to that. Billy and I respect him 100%. And I sent the board president an email requesting to hand out flyers in the lobby. I was denied. I asked at a board meeting, he said he was gonna take into consideration to make up a policy. I expected that, it never happened. There's no policy still. I asked this board, could they look at that and come up with some type of policy for canvassing in the lobby? And I personally think that it wouldn't be a good idea to do it, because this, about 2 weeks ago, the recall was in the lobby, as members entered, and I sit there, same day we had the Easter egg hunt, asking people to join social committee. And I heard a person belittle the president because that's why they wanted them to sign a recall. I didn't think that was the appropriate thing to do in the midst of people coming in to be checked into the community center. And because that happened, I brought it to the attention of the president and the vice president. And Mr. Trainer sort of written request in. He came up. They approved his written request. He sat down and started doing the same thing, and it became an argument. So if it can be done any place other than the lobby, I think it would be a good place anywhere other than in that lobby and along the sidewalk to disturb the members as they're coming into the facility with their families and guests, and we have arguments going on out in the lobby. It's not a good thing. If we have it back here, I suggested having it in the cafe area. That's based upon those situations. I don't think it would be appropriate to have that type of campaign in the lobby. Putting up forms and signs that I agree with, but someone else might not agree with, still again is not appropriate. It should be done someplace else other than out there in that lobby when we have guests and members coming here with their families. Is that good enough?
Not really. Not at all.
I know it would never do, so.
No, because, hold on a
Before you
minute,
go,
because
Could I
first
make a
off, I
comment,
didn't read
please?
the document here.
Hang on.
could I make a comment, please? I think that the issue that was being addressed by the front lobby has been solved. And I think that this is too restrictive of the rights that we as property owners have and as U.S. citizens have to voice our opinions. Now, and as long as the front lobby is cleared and the hallways are cleared, I can't see how any else on this policy applies.
Well,
that.
the only thing I would say, you know, we're all talking about our right to free speech, but
Goes both ways.
it goes both ways, yeah. I mean, if somebody got up there, we've got an election coming, do we want to open this up to canvassing for the election? You know, there's a limit.
Yes.
That's what
You
it's
canvass
for.
when you
No.
get elected.
Yeah, that's what it's for.
No, I mean the general election.
What's the difference? It's right here, in your own policy, it says, does not directly involve the business or operation of the association. I'm sorry, but the recall is the business of the association.
No, it's not.
Just like the election is. Per 720, it is.
No, it's not.
Yes, it is.
No.
It is.
Yes, it is.
Yes, Mary, speak.
Okay, what Jen just said doesn't directly involve the everyday workings of Holly Legacy Recreation Center. Well, it has involved everyday workings of the Recreation Center. It has involved the employees of Holly Legacy. It has disturbed the members from the emails that we've gotten. So, like, yes, it has involved
So has the board.
members of Holly Legacy. So, in that respect, I'm sorry, I respectfully disagree.
But that's what Bill said, the lobby is done and there's no problem anymore. This is just dictatorship and nonsense, and you paid an
I
attorney.
can barely hear you.
720.
If you want to come up and speak, can you come up and speak so she can hear?
720 basically says, no entity or entities shall unreasonably restrict any partial owner's right to peacefully assembly.
Okay,
That's what we're doing.
unreasonable.
The only one that got unpeaceful is one of your supporters.
That
Okay,
people have called and asked, are they there? I don't want to come and bring my children through that. People have written, and that's true.
And we've also had people.
Just because, man, just because this is what you support and what you want, it doesn't mean that everybody does.
Everybody doesn't have to.
Okay, but they have to go through it. This is a recreation center.
That's right.
You can go down,
However,
you can go down to the beach house and rent it and have the meeting or whatever.
However,
But why should people have to be subjected to what offends them?
okay, you say people called up here wanting to know if anybody was in the lobby for a recall because they didn't want to come. How many people called up here asking if we were in the lobby so they could come up and drop off their paperwork?
Right.
It's not a question of how many.
They're members just like anybody else.
Okay, but so we have the rule of the majority or we ignore minority rights?
There's nobody being ignored.
No.
Well,
They have every right to come up here and walk right through.
The rights of the people to just come into the rec center and not be bothered with either side, who just want to come in, who just want to use the gym or use the pool, bring their kids up here, their rights have to be respected too.
720 said we have every right to assemble.
Not a
Period.
recall.
Peacefully.
Not a recall.
It doesn't
It
say that.
says peacefully assembling,
Not a recall.
no matter what it is, like the town hall meeting, for
Not a
example. Town hall meeting,
say not a recall.
for the town hall meeting. That was a peaceful assembly which you tried to shut down.
No, I did not.
I have an email that says otherwise.
All I said was to take it off the marquee, where there was never an attempt
But
to stop the.
Why would you want to take it off the marquee?
What was the
Why?
exact?
What was the abusiveness of having that on the
It was
marquee?
on the marquee, there hadn't been permission asked.
You said it had to be board sanctioned. A town hall meeting
Well-
does not have to be board sanctioned.
Okay, but was the meeting stopped?
You tried to stop.
No, I didn't try to stop the meeting.
Would you like to read the email?
Tell me how the meeting was stopped. Did I ever say the meeting will not take place?
You
When
asked
did
if
I ever say that the meeting would not take place? No.
you said it was not board sanctioned.
Okay, but that's not the same thing. That's completely different.
Well, what did you mean? What did you mean when you said that? If you say something like that and
I
then you want,
did not
excuse me, I'm talking. If you say something like that,
Say
and
what?
then you want, that wasn't sanctioned, okay? If you say something like that, and then you also turn around and say, you want to take it off the marquee.
It doesn't mean it's cancelled.
No, it doesn't mean it's canceled, but it does mean you're trying to obstruct it, in my opinion.
Manipulate it.
Well, it was not cancelled.
Because they carried forward, and
There
regardless
was
of
no
anything you did,
request.
they decided to go ahead with it.
There was no request by me to cancel the meeting.
I think Bill is correct. that lobby is taken care of, there's no problem, everybody's happy but for you to go through all this dictatorship and it's only approved by the board, for the board, it's not right. It's not part of the 720 rule. You're right. She should listen to you're the vice president, you have a good opinion. I think she should let it go, and I think you should talk to her about letting it go because it's not correct and it's not fair to the association. Now, everything else is solved. Nobody's complaining anymore, and Beth had a good point. There were a lot of people that approached me, how come the table's not there? It's convenient for me to come by when I drop my kids off to pick up one of those recall forms. So you've got people saying one thing, I don't think it should be, nobody should be confronted, that's not right. You know, people that are bringing people in to buy houses, we don't want to see that. We don't want to see arguments. That's done. It's taken care of. Bill said he's happy with it. Let's just table everything else that you spend how much money on a lawyer again, because we're going to run out of money for lawyers here soon, and just go with that first thing that was approved, and let's just delete everything else, and I think everybody would be happy for that.
Yes. I agree.
Thank you.
Well, let us table this in case,
I'd like to make a motion.
what,
Read your email first, Matt.
Well, let Bill make a motion.
I'd like to make a motion that the rules and regulations regarding campaign, canvass, and signposting that was given to the board to review, that it be canceled.
Absolutely.
And we leave the number one item that we had already approved about the canvassing and campaigning in the center or in the front of the center.
Right.
And the walkway coming up.
I second it. Or do we have to discuss it further?
oh,
I second it.
want to speak?
I was just gonna revert to the email that you sent about. Please read it. Basically, it says all poster boards, flyers, petitions, recall information need to be removed from the rec center. Both sides. Also, the town hall information should be removed from the marquee as it is not sanctioned by the board. In addition, email blasts need to be approved before they are sent out. Right. And then Bill Crouch said something, he sent another email saying, we were down earlier today and we forgot to remove the marquee about the town hall meeting. Please remove it ASAP. Also, the president will be forwarding an email blast for you to send out. It will be needed to be sent out immediately. And that was concerning the town hall meeting.
Yeah, and I think it is fair that the email blast not be used for propaganda. Yes, for propaganda.
We have a motion and a second. Let's try to keep the discussion based upon that.
Right.
Are you saying that the members have the right to campaign in the lobby?
No.
Do you have a policy for that?
Yes.
Yes, that's what they passed last night.
The members can campaign,
Anywhere but in front of the lobby.
Yeah.
Where?
And the sidewalk.
they can
The
campaign.
sidewalks leading up to the foyer and the front lobby and the hallways.
And not in the lobby?
Not in the lobby,
They
not
can
in
come
the
back here,
hallways.
or they can come here, or they can have, where.
Tennis courts.
Thank you. Because that's what I asked questions last year and that's all I wanted to see.
Yeah.
That's right, Earl, it's not right for them and not for you.
Just to save some time, you can go ahead and vote on this and say do away with it at this point. Later on, if you'd like to revisit this, you have that opportunity, but for now, let's just move on.
Yeah.
Okay, those in favor of retaining the policy as it is with just number one, the small
Do we like
policy?
number one? Well, I still have this.
No, okay,
You want to
the
change
old,
policy.
okay, well, we got what it is, so we're not gonna do any of this. We're just gonna leave it as it is. Okay, those in favor, say aye.
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 Mary?